Good morning. Thank you for joining Mayor Brown's client webinar. My name is Jason Elder. I'm a capital markets partner based in the firm's Hong Kong office. This webinar is intended to be a conversation to cover updates and recent developments with the Holding Foreign Companies Accountable Act and related legislation and rulemaking that's happening in the United States. I think when we last spoke with our Asia-based clients and friends, we were covering the House passage of the bill, and it was tabled with the Senate. We were also facing an uncertain election outcome, and we knew that we would be getting some sort of a pause, most likely from Congress, as the election cycle completed. We do have some updates, and I think things are going to start moving a little bit faster now, and we've been getting an increasing number of client inquiries from issuers, companies considering listing, and their advisors in Asia. So we thought it was the right time to maybe sit down again and talk about the recent developments, what this means for market participants, and what are the anticipated next steps that are going to be coming down the road, both from Congress, from the president, and from the SEC. I'm joined today by my partner, Tom Kollar, who's a capital markets partner sitting in our Hong Kong office. Tom's got extensive experience advising issuers and underwriters on capital markets offerings. So, he's working with me to respond to client requests about how to address these potential legislative developments. And I'm also joined by Christina Thomas. Christina just joined the firm in the last month, and so we're welcoming her not only to this client webinar, but also to the Mayor Brown family. We're very happy to have her join us. She joined from the SEC, where she has over 7 years of experience with the staff, with a heavy involvement in rulemaking and the SEC process. So her views on that will be very important. She finished her last position at the SEC as a senior advisor to Commissioner Roisman and was heavily involved in SEC rulemaking in that role. So I think her views will be especially helpful as we try to understand what the next steps will be. So let's go ahead and get started and talk about what the recent developments are. And maybe, Christina, I'll turn it over to you for an overview of the Act and the related SEC rulemaking and some of the other stuff that's going on.
Thank you, Jason. So I'll start by saying that looking at the current landscape of bills and recommendations and potential rulemakings can be a bit confusing. So I thought it might be helpful to give a little bit of background on everything that is out there and the direction in which this issue seems to be heading in the U.S. So the Holding Foreign Companies Accountable Act, I'll refer to it as the HFCA. I'm not sure if that's less of a mouthful or not, but this is the proposed legislative fix to the problem of PCAOB restricted access to foreign audit firms. So the bill would amend the Sarbanes-Oxley Act, which created the PCAOB, to add language that would require two main components, as I see it: disclosure and delisting. The disclosure to the SEC would be required after the SEC identifies reporting companies that use an audit firm that, one, is located in a foreign jurisdiction, that, two, restricts the PCAOB's ability to inspect or investigate the audit firm as determined by the PCAOB. Each reporting company will be required to submit to the SEC documentation that establishes that the company is not owned or controlled by a governmental entity in the foreign jurisdiction. Specifically, in each non-inspection year, companies will have to publicly disclose in their Form 10-K or their Form 20-F information about the audit firm, shares owned by governmental entities in the company's foreign jurisdiction, the ownership interest of governmental entities in the foreign audit firm's jurisdiction, the name of each official of the Chinese Communist Party on the company's board of directors, and whether the company's organizing document contains any charter of the Chinese Communist Party. The other component is a trading prohibition for non-compliance, and that's the delisting component that I mentioned. If the SEC determines that a company has 3 consecutive non-inspection years, the legislation requires that the SEC prohibit the securities of the company from being traded on a national securities exchange or through any other method regulated by the SEC. So that would include over-the-counter trading as well. Now, the legislation allows for the removal of the trading prohibition if the covered issuer certifies to the SEC that the covered issuer, as they call them, has retained a registered public accounting firm that the PCAOB has inspected under the legislation to the satisfaction of the SEC. However, if the covered issuer or the company subsequently falls out of compliance again, even for just having one non-inspection year, the covered issuer would have to wait another 5 years before it can apply to have the subsequent prohibition removed. Now, as I mentioned, the HFCAA is the proposed legislative fix, and that bill initially passed in the Senate this past May. Passage by unanimous consent in the Senate of a bipartisan bill would have signaled to the executive branch that this would also likely pass in the House. And given President Trump's position on China, there is little doubt that he would sign the bill into law. So when the president convened the President's Working Group on Financial Markets, which I'll refer to as the PWG this summer, he convened them to address the same problem of restricted access to the work of audit firms in China. And it was not surprising that the PWG would then look to the HFCAA in drafting its recommendations. I'll note that the SEC chairman, Chairman Clayton, is a member of the PWG. So it's not surprising if the recommendations reflect, in his view, the best way to address the problem, balancing both investor protection and maintaining fair, orderly, and efficient markets, both of which are central tenets of the SEC's mission. I'll note also that he put out a statement in August directing the SEC staff to begin working on implementing the PWG recommendation. And while there is overlap, there are some differences between the HFCAA and the PWG recommendation that I think are worth mentioning. First, the PWG recommendation does not provide a corresponding disclosure requirement. Second, the delisting component in the PWG recommendation is a bit more nuanced and specific in how it could be implemented under the Securities Exchange Act. So the PWG report recommends enhanced listing standards to require as a condition to initial and continued exchange listing in the U.S., PCAOB access to work papers of the principal audit firm for the audit of the listed company. So if a company that is based in a non-cooperating jurisdiction cannot meet that standard, it would be required to engage a U.S. audit firm to serve as the principal auditor of the company's annual financial statements through a co-audit arrangement with the foreign audit firm. And rulemaking or standard setting by the PCAOB, the SEC, or both would be needed to require that the U.S. firm supervise the work of the foreign firm. One other point worth mentioning is that to reduce market disruption, the new listing standards could provide for a transition period until January 1st, 2022 for currently listed companies to come into compliance, but the PWG recommendation makes no such transition accommodation for companies that would be seeking to list on an exchange. There would be a couple of ways in which this new listing standard could be implemented. One way suggested by the report is that following informal discussions with the SEC, the listing exchanges could voluntarily file proposals with the SEC to amend their listing standards. The SEC could also on its own pursue a rulemaking to amend directly the exchange's listing standards. And I think it's worth noting also that over the summer, NASDAQ did propose a rule. It would allow NASDAQ to deny listing or continued listing or to impose additional listing standards in its discretion, including those requiring higher assets, earnings, or liquidity if NASDAQ has concerns relating to the audit of a potential or existing listed company. This provides the exchange with a lot more discretion than is contemplated in the HFCAA or the PWG recommendation. So I think especially if the HFCAA becomes law, that proposal likely wouldn't be enough. But going back to the PWG recommendation, I thought it'd be helpful to sort of address the question of why is there this dual track and why wouldn't the SEC wait for the legislation? The issue of China restricting the PCAOB's ability to inspect audit firms is not new. This is something the SEC has been trying to address for over a decade. I think the intensified interest from both the legislative and executive branches this summer really propelled the issue and forced consideration of how SEC rule changes could address the issue. And so while a unanimous passage in the Senate suggested that this bill would become law, there was not certainty. The year is almost over. Chairman Clayton of the SEC leaves that position at the end of this year, and the bill still has not been signed into law, although it seems that we are much closer to that now. But I think the PWG and the SEC decided to begin preparing for a statutory mandate, but also determined that the SEC could act on its own, even if the bill never became law. So, Tom, now that we are anticipating that we may see some rulemaking in this space in the next couple of weeks, will you talk a bit about how companies and their advisors in Asia are reacting to these developments?
Sure, Christina, thank you. The way existing issuers in Asia are looking at this now and the advice they're seeking are really two different areas. One, they're seeking advice in take privates and how to buy back the public float and delist and deregister from the U.S. SEC reporting and compliance regime. So, in other words, known as going dark. The issues that we're really discussing are come into three buckets. One, there's a cost associated with buying back the public float. So when the controlling shareholder or management or a consortium elects to buy it back, they're going to have to finance that. Second is gaining shareholder support. Note that most of these entities that are listed in the U.S. are typically Cayman, so you're going to be subject to the merger regime in Cayman Islands, and there are some shareholder aspects that need to be dealt with. So it's really understanding how much shareholder support we have and designing a strategy around taking the best course of action through the Cayman regulations. And finally, this is a very process-driven exercise with respect to takes privates, and it can be quite time-consuming. Usually it takes anywhere from 6 months to a year to conduct the take private transaction, and then the delisting and deregistration from the SEC typically takes about 110 days. So it's not something that happens overnight, and you need to plan for that and bear that in mind. The other thing that PRC-based U.S. listcos are concerned about, and we're discussing with our homecoming offering. So either listing back in Hong Kong, Shenzhen, or Shanghai, at least as far as Hong Kong is concerned, secondary listings are probably one of the bigger topics, and we've seen a few of those recently, not necessarily in connection with this rulemaking, but we've seen a few major secondary offerings here in Hong Kong. And also potentially a primary offering. Now, the issues that we've been discussing typically are around meeting the listing requirements in Hong Kong. Some of these issuers, and there are about approximately 200 in the U.S., many of them would not meet some of the market cap requirements. So we're looking at specific avenues for them to entertain either secondary or primary listing in Hong Kong. Now, the other stakeholder in this are new issuers. Now, we've seen recently several PRC companies that have listed in the past couple of months, such as Lufax and Xpeng. And as Christina had mentioned, there'll be no transition period for new issuers that are coming in with respect to the regime. So they do need to be mindful of the current rulemaking, which really takes it back to what do we think the next steps are. So Christina, maybe you can tell us what we think the next steps are and what this looks like going forward.
Thank you, Tom. So I think the big question is, will President Trump sign the bill into law? And I can't really think of an answer other than yes. I see no reason why he wouldn't, especially since this is an issue that he has personally said he wants a solution to the problem. But I do want to note that the timing of these developments creates some uncertainty. As I mentioned, the SEC chairman is on his way out this month. The president is obviously going to be leaving office next month, and the administration is going to change. So if President Trump does not sign the bill into law in the next couple weeks, there is a good chance that the SEC would propose a rule in line with the PWG recommendation before the year ends. The SEC is unlikely to implement a statute if there's not currently, a statutory mandate. But if the bill is signed into law, the SEC will have to implement the disclosure portion of the statute within 90 days. They may already be prepared to do that this month, but regardless of whether the SEC proposes a rule this month or in 3 months, when the SEC does propose a new rule, it's, I think, helpful to know a little bit about how that process goes. We have something called the Administrative Procedure Act, which requires notice and comment. And that means that the SEC will propose a rule with potential alternatives and questions for the public. And anyone who is interested can write in to express views, concerns, and recommendations on the proposal. That comment process will add a minimum of 30 days, probably more like 60 days. And then the adopting release would have to be drafted and contain responses to comments from the public. So that could take another couple of months, depending on how much of a priority this is for the next administration. But if it were a statutory mandate, there likely wouldn't be too much flexibility to revise the proposal in response to comments. That said, the SEC mission requires that it facilitate capital formation and ensure fair, orderly, and efficient markets. So this means that the SEC is going to have an obligation to implement the statute in a way that limits market disruption. As we mentioned before, the PWG already suggested delaying implementation until January 2022 for this very reason. So I would anticipate that the SEC will try to provide some alternatives in the proposal wherever they think that they have flexibility in implementation. But given the bipartisan support and the investor protection concerns at the core of this issue, I imagine that a rule could be adopted even if the commission is operating with 4 commissioners and no permanent chair at the beginning of the next administration. So, this is all to say that while there is uncertainty right now with precise timing, this could move relatively quickly once the bill is signed into law and or the commission proposes a rule.
And I think, Christina, that's been a key focus for issuers and advisors in Asia in terms of determining the potential impact of the rulemaking, is precisely the timetable and the transition period that's going to be available there. I do think that for people who want more background on this, we recommended these materials in our last webinar, and I'll do so again. Just that the PWG report from the task force is fairly readable, and for those who are talking to their clients or to thinking about it from their perspective and need to explain how we got to this point, I think it provides a pretty useful summary of the PCAOB issues with China and Chinese regulators over the years. As Christina accurately noted, this is not a new issue, and so sometimes knowing a little bit of the history between the regulators helps to understand, how the rulemaking is going to move forward and how we got to this point. So I'd commend the PWG report, and then I would also note that Christina and the team published a client alert today. And that alert is just a few hours old that covers some of the developments with the HFCAA, and that I would also commend for further reading for people who want more background on the materials covered in this presentation. So, Christina, as you think about the SEC rulemaking process right now, I guess what I'm hearing from you is that because the SEC's had this parallel process running, and because it looks like there would be a statutory mandate after the president signs it, it would become law, and the SEC would be charged with promulgating the relevant rules. Your feeling is that they're already working on this, and that there's already a draft within the SEC that's circulating. Is that right?
Yeah, so the chairman publicly stated in August that he had directed the staff to start drafting a rule that would comport with the PWG recommendation. So, no reason to believe that the staff didn't get working on that right away. But again, there's a bit of a question if that rule proposal is ready, but it doesn't contain all the components of the HFCAA. I think there's a question of, is the staff ready to sort of add those components in? Have they drafted them, and are they waiting to plug them in if the bill is signed into law, or is there a chance that the rulemaking goes in sort of 2 pieces, the PWG recommendation first, and then the rest of the HFCAA in a second rulemaking, or a third alternative? Do they decide to wait and put it all out together and leave it to the next administration? So a fair amount of uncertainty, like I said, given just the timing of the administration change right now.
But that uncertainty largely relates to the disclosure aspects in the HFCAA, particularly relating to the Chinese Communist Party disclosure, and the issues around co-audit and the actual PCAOB access to audit papers. That piece is pretty consistent across the Act, across the PWG, et cetera, although the PWG provided some permutations. It's really that additional disclosure piece that potentially the SEC is a little less enthusiastic about or needs to be added in if it's signed into law. Is that right?
I think that's right. And, I'll note that the Commission takes its statutory requirements very seriously, but this is sort of reminiscent to me of the resource extraction rule that was required by the Dodd-Frank Act. It requires disclosure that people could argue falls outside of the realm of materiality. So, information that a reasonable investor would need to know to make an investment decision. So, the SEC staff recently put out some guidance to China-based issuers. And while the PCAOB's ability to inspect was a main focus, and certain other issues that are pretty unique to China-based issuers, while those were all mentioned in the disclosure guidance, there were no questions about ties to the Communist Party. That said, the guidance does provide a focus on China's restrictions on the PCAOB's ability to inspect or investigate audit firms based in China and Hong Kong. And additionally, the guidance discusses the existence of laws, rules, and regulations that provide the Chinese government with significant authority to exert influence on a China-based issuer's ability to conduct business or raise capital. But, these are staff, this is staff guidance, so it doesn't have the sort of binding legal effect that an SEC commission rulemaking would have. And it also just doesn't have that bright line disclosure that you would say is directly pulled in from the FHCAA.
And just one last question, Christina, as you mentioned the analogy to the natural resources extraction rules, for the people that are dialing in that maybe didn't live through that like we did, can you just give a very high level overview of what happened in that situation? And what I'm particularly thinking about is just the length at which the comment process dragged out and how long it took for anything really to be enacted or to be implemented.
Right. So as I mentioned, that rule comes from the Dodd-Frank Act, which was enacted over a decade ago now. We still don't have a final rule. That is one of the probably most tortured rulemaking processes in SEC history. But it was, the first rule that was adopted was struck down by the courts. The second version was struck down by Congress, and the SEC was basically told, go back and try it again, and you can't come back with anything that's substantially similar. So the SEC has been working on that rulemaking for now almost a decade, and it's I guess it's a bit difficult because, as I mentioned, it doesn't have sort of the same focus as the SEC usually has in rulemakings where they're trying to elicit material information. It's more of a focus on a human rights aspect that's arguably not closely tied to an investment decision. And so, I think you can sort of draw parallels here and say, if this is bright line disclosure that if it's required by Congress, of course the SEC will implement it, but it's a little more it's a little more difficult to see the SEC just proposing it on its own without the statutory mandate.
That's great. Thank you. Go ahead, Tom.
Christina, just can we just talk about timing again? And I know this may be a review because I don't think that's changed in the rulemaking, but could we just talk about a little to kind of crystallize for the listeners, with the potential transition period and the number of years for noncompliance before a voluntary delisting may happen. Can we just walk through that so we kind of have a sense of when we think, the impact could really be felt for, PRC-based U.S. listcos?
Yeah, so for those companies that are currently listed, I think that based on what we know, if a rule is proposed and provides for that 2022 transition period. And then it also brings in the sort of 3-year non-inspection dates from the FHCAA. I think the earliest you could see delisting would be 2025, based on adding those dates together. That said, if the PWG recommendation doesn't provide such a strict sort of guidelines in terms of 3 years and then you're out, but it does provide, it suggests that there could be rule proposals by the listing exchanges. And I think, that tends to take a little bit of time because that is something that, in addition to the SEC rule proposal, if then there were a rule proposal from the exchanges, there would be an additional comment period there. And then, generally speaking, when exchange-listed companies fall out of compliance with continued listing standards, they're notified by the exchange and given a period to regain compliance. And so then you'd almost be moving sort of to the standard timeline for listed companies that fall out of compliance with exchange listing requirements. So I think that, given the likelihood that the FHCAA is going to be signed into law, the 3-year period's pretty clear in the language of the legislation, and so I don't see much flexibility around that. And so I think it's probably a good assumption to say that the way things are going, it would be about 2025 before we started to see actual delisting in this space.
Okay, thank you, Christina. Well, we have promised to our participants that we would keep this bite-sized today and try to just give updates and not go on for too long. So I think we're going to draw a line under it there. I want to thank everybody for attending. We will keep you posted with subsequent developments. And if you have additional questions following the webinar today, please feel free to reach out to any of the presenters or your normal Mayor Brown contact. We're all happy to help and happy to talk with you. This will be recorded and posted on our website, so if you want to recommend it to colleagues or friends, please do so. And if you like it or share it on social media, we greatly appreciate that too. So thank you for attending. We appreciate it and have a great day.